Welcome to our deep dive on the Citizenship Trap, how mandatory foreign military service can collide with your U.S. immigration plans. In this video, we will explain the timeline conflicts, the risks, the strategic choices, and the professional steps you should consider. We will also include a clear disclaimer that this is educational information, not legal advice. To begin, here is the problem in one sentence. Your U.S. work-to-green card timeline can directly collide with mandatory conscription rules in your country of citizenship. In the next sections, we will break down how these clocks tick, why delays matter, and what strategic pathways are typically considered. Next, here is our roadmap. We will cover the high-stakes timeline, overseas waivers and deadlines, the stay versus go dilemma, the push for citizenship strategy, the critical risks of evasion, a practical action plan, 2 short quizzes, key takeaways, and a final disclaimer. First, let us visualize the overlapping timelines. On one side, the H-1B and employment-based green card process can take several years, even with efficient processing. On the other side, many countries enforce mandatory military service, with overseas travel waivers that typically expire in the mid-20s. Once those permits expire, you may be required to return home to serve, and failing to do so can create legal and logistical consequences. The transition to the next section will focus on how these waivers operate, and why their expiration is critical. Next, let us look at overseas travel permits or waivers, which are often granted to individuals studying or working abroad. These are temporary, and usually expire in the mid-20s. When they lapse, you may be required to return to your country of origin to fulfill mandatory service. If you do not return, you can face consequences such as travel restrictions, denial of passport renewals, and potential criminal penalties if you re-enter your country without serving. Now we will compare 2 strategic paths: interrupting your career to serve, or attempting to secure U.S. status first. Now let us compare the 2 main pathways. Option 1 is to return and serve, complying early and resolving the obligation at the cost of pausing your U.S. career and potentially losing progress and income. Option 2 is to remain in the United States to secure status as quickly as possible, for example by advancing employment-based permanent residency filings. This second option may include planning for lawful renunciation of your native citizenship before you are classified as an evader, where it is legally possible. However, it also carries risk if your overseas waiver expires and your passport cannot be renewed. Next, we will map this decision-making process visually. Then, consider this flow. You begin by determining the waiver expiry date. If you have more than 2 years remaining, you may initiate employment-based filings promptly, while tracking conscription deadlines carefully. If you have less than 2 years, you should consult both a United States immigration attorney and a native country conscription law expert immediately. From there, one branch is to serve now, which clears the obligation but pauses your U.S. trajectory. The other branch is to stay and file for permanent residence as early as possible, while maintaining lawful presence. Within that branch, evaluate whether lawful renunciation prior to any evader classification is viable. If it is, you may pursue that path with counsel. If it is not, reassess with counsel and create a contingency plan. Moving forward, the push for citizenship strategy involves maximizing time in the United States under lawful status, progressing through permanent residency, and eventually pursuing naturalization. In some countries and circumstances, a crucial step is to lawfully renounce native citizenship before any evasion classification occurs. This requires detailed legal coordination and a high degree of personal commitment. Next, we will examine the risks of attempting to outrun these deadlines. Next, we need to highlight the risks of attempting to avoid or outrun conscription deadlines. First, you may become effectively immobile if your overseas waiver lapses, because international travel could risk detention or enforcement, and returning home may trigger conscription or legal action. Second, your country of citizenship might refuse to renew your passport, which complicates your mobility and documentation, even if you hold a United States green card. Third, there may be legal exposure if you return to your country without having served. Now, let us turn these qualitative risks into a simple matrix. Now, review this matrix. When the waiver is active, travel is generally possible, passport renewal is likely, and legal exposure is low. If the waiver has expired without service, travel becomes risky, passport renewal may be denied, and legal exposure ranges from moderate to high. If you have served or are exempt, conditions return closer to normal. If you have lawfully renounced before any evader classification, Travel depends on your United States status and documentation, while the previous citizenship passport is no longer applicable. Legal exposure is low if the renunciation was properly completed. Next, we will walk through a step-by-step action plan. Next, here are practical steps. First, audit all key dates, including visa validity, immigrant petition milestones, and waiver expiry. Second, retain 2 attorneys early, a United States immigration attorney and a native country conscription law specialist. Third, file for employment-based permanent residency as early as eligible and avoid unnecessary delays. Fourth, model different timing scenarios, such as a waiver expiring in 6, 12, or 24 months. Fifth, if possible within the law, plan for renunciation before any evader classification. Sixth, maintain strict compliance across all records and status. Seventh, have contingency plans, including backup immigration options and employer coordination. Up next, a quick decision support mind map. Now, this mind map summarizes a defense plan. The legal branch includes a United States immigration attorney and a home country conscription specialist. The documents branch includes passport renewals, waiver letters, proof of residence, and employment letters. The strategy branch highlights early immigrant filings, premium processing where appropriate, backup status, and a renunciation path if lawful and viable. The timing branch tracks waiver expiry, filing calendars, and decision deadlines. The personal branch considers family impact, financial buffers, and mental health. The risks branch lists travel freeze, passport denial, and possible criminal exposure. Now, here is a quick quiz. If your overseas waiver expires while your United States green card is still pending, which risk is most immediate? Option A. You automatically become a United States citizen. Option B. Your native country may refuse to renew your passport. Option C. You can freely travel internationally without issues. Option D. Your United States employer is legally obligated to protect you. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is that your native country may refuse to renew your passport. That is often an immediate consequence following waiver expiry, and it greatly complicates international travel and documentation, even if your United States immigration process is ongoing. Next, let us do one more quiz question. Here is the second quiz question. When should you consult both a United States immigration attorney and a home country conscription law expert? Option A. Only after your waiver has expired. Option B. As early as possible, ideally with 12 to 24 months before waiver expiry. Option C. Only after you receive your United States green card. Option D. Never. Online forums are sufficient. You may pause the video now to consider your answer. We will reveal the answer next. The correct answer is as early as possible, ideally with 12 to 24 months before the waiver expires. Early counsel allows time to organize filings, anticipate scenarios, and evaluate whether lawful renunciation is possible before any evader classification. Next, we will present key points and a short markdown disclaimer. Before concluding, here is an important disclaimer. This video is for educational purposes only and does not constitute legal advice. Rules vary by country and change over time. Always consult licensed attorneys in the appropriate jurisdictions, including a United States immigration lawyer and a home country conscription law specialist. You should not attempt to evade laws. Work within lawful frameworks under professional guidance. Next, we will summarize the key points. In summary, these are the key points. First, your employment-based immigration timeline can collide with conscription windows. Second, expired waivers often trigger travel risks and passport renewal problems. Third, you face a strategic decision between serving now or attempting to secure United States status first. Fourth, in some situations, lawful renunciation may be possible, but only with professional advice. Fifth, early and dual jurisdiction counsel is essential. Finally, we will wrap up with a brief summary and a call to action. To conclude, map your dates and model multiple scenarios. Engage the right experts early. File promptly when eligible. Consider lawful renunciation only with precise guidance. And keep documentation and contingencies in excellent order. Up next, a final thank you and call to action. Thank you for watching. If this video helped you, please like, share, and subscribe, and tell us your questions or experiences in the comments. Your insights could guide others facing the same dilemma.